Okay, I understand that y'all have y'all need to take something up with the court before we bring the jury back in.
Yes, Your Honor. We had a chance to meet with defense counsel yesterday as we are about to call a forensic technician that processed the scene at 122 Canebrake. She was responsible for taking all the photographs of the scene as it was. And like I said, we went through each of them with defense counsel, and there are a few where they've raised an objection that specifically states Exhibit 63, 64, 65, and 66. And I'll pass them up to the court. I'm also going to pass up to Your Honor.
Thank you.
A copy of State v. Haight or Hawes, and that is 423. That is 423 SC 118. A copy of defense counsel as well. The state believes that based on Hawes and based on the circumstances of this case, that the specific photograph should be introduced to the jury as is. State v. Hawes is a very similar case with regard to the cause of death, and that it was a stabbing death, and the Supreme Court confirmed that the admission of the photographs was proper, and I'll direct the court specifically to Head Note 6, where the photographs of the victim who was stabbed to death should have been admitted. It was not an abuse of discretion, where they went to show the circumstances of the crime scene and the location of the body. They go towards the issue of malice in this case. The state intends to elicit testimony from the forensic technician as to the significance of where the body was found, the actions that were likely to have taken after Ms. Parcell was stabbed with regard to the body, and the significance of what the blood pattern indicated. Again, I believe State v. Hawes is on point with this specific issue, and especially where we are offering testimony to extrapolate inferences that we would provide to the jury as to the circumstances surrounding Ms. Parcell's death.
Defense counsel.
Your Honor, our position is just under a 403 analysis. I'm not sure there's any, I'm not sure what the relevance is. They say it goes to malice, but they can certainly describe the crime scene without having to show those photographs. So I would say under a 403 analysis, very little probative value to those pictures, and whatever probative value is outweighed by the potential prejudicial effect. I would also note the state has prepared for 2 of those photographs. They've prepared another set of photographs with the deceased blocked out of the photograph. So if Your Honor does see probative value, we would ask that those be substituted for the those 2 photographs. And I would also add, they have other photographs of that room that are taken from a wider angle and from that are not close-ups of the of those areas that they are seeking to point out. So we would ask that that those other photographs that they have, which I think they can show to the court if the court needs to see them, but they would be sufficient to point out what they want to show to the jury.
I mean, obviously, this is the first time I'm looking at the photos. What is, I guess, the difference between 63 and 64 is you've got the victim is in it.
That's correct, Your Honor. These photographs all go to show, and what the state's going to argue, is the actions that were taken after Ms. Parcell was stabbed, and it specifically goes towards the placement and the actions taken towards her body after that stabbing. As you know, the state is charged with proving premeditation to this murder. The actions that the state is alleging Mr. Hughes took, obviously during this incident, but afterwards, are highly probative to show his state of mind and the deliberation that he took before committing this murder and the steps that he took afterwards. In a normal instance, if this were simply a spur-of-the-moment stabbing or an instance where there isn't evidence, or the state would proffer that there is evidence in this case that actions were taken after the act itself to go to show premeditation, I could see where it would be a different analysis. But these specific photographs are clearly probative of those actions that we are arguing that Mr. Hughes took in this instance. So again, the state would argue that while we do have several photographs that show different angles, they are all probative. And I don't believe that the danger of unfair prejudice or spurring the emotions of the jury substantially outweighs that probative value that we're putting forth to the jury.
Okay. I'm going to take a quick break, and then I'll be back, okay?
And, Your Honor, we would ask that there are some other photographs that we are not objecting to. We would ask that Your Honor be allowed to view those as well, so you can look at those in conjunction with the ones you've been given to see if those are necessary as the state says. And also, I would just add that premeditation is not an element of murder, so they don't. I think that's not a correct statement to say they have to prove premeditation.
Yeah, I'm happy to pass these up for your review.
Any response to that?
I will say that malice is
Malice is definitely.
an element that the state is charged with proving, and evidence to that effect is obviously extremely valuable. And the evidence from this crime scene is a huge portion of what the state wants to offer to the jury for them to make that inference as to malice in this murder. So again, I've passed up all the photographs of the specific crime scene that the state intends to introduce, as well as the two photos upon Your Honor's ruling that those two specific photos need to be redacted. We have done that.
Well, you've redacted 67 and 68, and those are coming in by agreement.
Well, only if you rule the other ones are not.
I got you. Okay.
Yes, we would not have an objection to the ones where the deceased is blocked out of the photograph.
Okay.